to Facebook Live presentation on estate planning with digital assets. I'm here today with my co-worker, Patti Jo Turner, and this is a rather cutting-edge presentation on estate planning with digital assets. We haven't run into this topic that much in the past, Patti Jo, but it's a question we get asked an awful lot about estate planning and these so-called digital assets. And it's gaining in relevance for a lot of our younger clients because they are online all the time with various accounts and videos and posts that they have on the line. And so it's going to become more and more important as the decade goes on. So we're also presenting on this topic because of the change in the law here in Pennsylvania. Prior to the beginning of the year, we did not have an actual law that allowed an agent under a power of attorney or an executor in a will to take control of digital assets and either manage them or transfer them to beneficiaries. So we're going to be talking just a bit about that law, and we're going to be talking about the steps that the average person perhaps should be taking with regards to these digital assets, these online assets, if they're concerned about estate planning. Maybe you spend a lot of time online and you have a lot of accounts and you're worried about what's going to happen to all of these at the time of your passing or if you become incapacitated. So one of the first topics that you and I agreed to cover was the question of what are these digital assets? What really are we talking about?
Right.
I mean, you and I thought, well, we're talking about cute little photographs that we have that we've uploaded.
That's
Kittens, dogs, and so on. That seems to be the most popular thing people have online, you know. But there's more to it than that. One of the most common form of assets, which is really maybe a digital communication versus an asset, is emails. How many people have an email account?
everybody almost.
Everybody does. So something has to happen to that at the time of your passing. And what if somebody wants to get into the email accounts? Maybe there's something important there they need to get into and they don't have the username and password. They need to get in there. What's the mechanism that allows them to do that? There's documents online. Think of these in blogs. There's lots of people at blogs. Our founder of our firm, Jeff Marshall, has a blog. Videos. Marshall Parkman Weber has a lot of videos and YouTube.
A lot of content there.
Think of all the videos that you see on YouTube. You know, I have a new dog and I'm watching these videos on how to stop your puppy from biting you, you know. 1.5 million views of this average video. So there are lots of videos out there. Posts on social media. Those are more interactive social media accounts. You probably already own the photograph if you posted something on there. But music and movie files, those have been around for a long time, whether it's iTunes or something else. Domain names, you know, if you have a website, then there's an asset there, a domain name to your website. Now, a lot of these are sentimental in value. They don't seem to have a lot of monetary value. But I mentioned to you the other day that I had seen this piece on a Sunday morning show about non-fungible tokens. Non-fungible, if you can say that 3 times, non-fungible fungible tokens, NFTs for short. And these are actually digitally recreated assets online. They could be photographs, they could be videos, they could be graphics, other forms of expression online, and they have significant value because the computer programming goes into them is very unique. And they're actually sold for a sizable amount of money if they're very creative. And so there's a whole market for NFTs, okay? And there's also the market for something we all know about and we've heard about in the news, and that's Bitcoin. It's a form of currency that can actually be used to purchase items. Can be traded and exchanged online. Bitcoin is the most popular of them. They call them cryptocurrencies. So those have value as well. So even though you may not be the person who owns a Bitcoin, or you don't have an NFT, for example, but you know that there is value to these assets online, and therefore there's a reason for this law that was passed in Pennsylvania. We have to have a mechanism to pass on these digital assets just like we had to pass on personal property.
So for clarification,
Yeah.
what about investment accounts that you strictly access online? Does that count as a digital asset or no?
No, I would say an investment account online is just information that you have to gain access to your investment account. Your money is actually still out there. It's still in physical form. You could go to the investment advisor and liquidate the account. They'd send you a check, and you'd have the cash, and that would be deposited into a bank account. So that's still personality in the world of estate planning. Bitcoin, on the other hand, you don't actually get anything physical. It's just in its digital form. So keep that in mind, that there's a big difference between physical property and digital. One of the big things that you and I also talked about is that with all of these usually these accounts online, there's a password and a username. And everybody seems to have a zillion of these now, because not only are we getting at the digital assets maybe, but we're accessing these social media accounts, streaming services. Everybody has Netflix or Hulu or whatever it is you've got. So there are scores of usernames and passwords. Where do you keep these so that if something happens to you, people can go online and get at these assets or at these accounts?
Which is the easiest way to do it,
Right.
but it's a lot to keep track of, even your own.
Yep.
Because they ask you to update them
Right.
and change them, and you might even have a dozen of
Yeah.
your own.
Right. And you were talking about having a master book or master tablet somewhere. Who everybody's got their own system. I mean, people have tablets at home, people have them saved on the computer, but you're going to need those in order to allow your agent under the power of attorney or your executor under the will to get at these accounts and either close them out or access the assets and transfer them. So there are other ways other than just a tablet at home to keep them, although that may be the most practical. Some people keep them on their home computer, and they need a username and password to get into the
To get into
home
that.
computer. There are online apps, 1Password and LastPass are two of them, where you can actually go online and list these usernames and passwords. So your family's going to be in a predicament if they can't get at these online assets that you have. Okay, so you need to educate them about where those usernames and passwords are located. So we now transition into the whole estate planning process, and what is it that we need to be doing from an estate planning standpoint if you have digital assets or digital accounts online. So can the power of attorney get at these accounts? And obviously if you have the username and password, you can just log in as the person who's disabled.
Yeah.
I mean, it goes on all the time.
Always.
You know, your mother has an online bank account, you have the username and password, you log in as her. So that's not always the issue with the power of attorney. Frequently it is, I don't have the username and password. I'm representing this person and I need to get at the money.
Yeah.
And how do I get those funds online?
Much more difficult.
Yes, okay. So, and with the executor, can you transfer ownership of an online asset to the beneficiaries in the will, just like you could a physical asset? So I have vinyl records at home, a whole bunch of them, and I want to leave them to you.
Thank you.
Pretty easy to do. I set up a will and say all the vinyl records go to Patti Jo.
And I back up a truck and haul them out.
And you haul them away. Now, what if I have an online music file, and I do with Amazon? Can I leave all of my online files to you as well? And the answer is it depends. That's not just a lawyer answer. It seems to be a lawyer answer in a lot of cases that it depends, but you may not actually own those online assets.
This is an interesting distinction.
Yep. What we're going to talk about is licensing agreements, and what you actually own varies from case to case. In many cases, all you have is the right to use the online asset that you think you've purchased. So lots of communications and social media content, you don't have any ownership interest in that file. You know, if you have a YouTube channel, you have the right to post there. Obviously, you have your videos that you've linked into the YouTube channel, but there's no ownership interest in the actual site that you have, whether it's a Facebook page or a YouTube channel. So let me tell you initially that Pennsylvania now has the Digital Assets Act, and that's an abbreviated title. It's actually much longer than that for our purposes. Know it as the Digital Assets Act. And it provides authority to an individual's digital assets or electronic communications, like emails, and a framework for all the companies who you're trying to go to and say, I want to get at these assets, to turn them over to either an agent under a power of attorney, a fiduciary, such as an executor, or a trustee under a trust. So there's sort of a framework for disclosing all of these and the rules they have to follow we didn't have prior to January of this year. So, like I said, one of the first things you have to ask yourself is, what do you actually own? And many of you have, let's say, an account with, I think Amazon has the Kindle. It's a classic case of you have this account with Amazon and you've been acquiring these books over a long period of time, you've been reading them, and you have 1,000 titles, and the reality is you don't own them. You only have a license to read them, okay? You've purchased the right to read those as many times as you want on your Kindle, but there's no ownership interest. And that's the case with most of these accounts out there, whether it's the Nook or even music files, whether it's iTunes. If you ever read those licensing agreements, you just have a right to enjoy the product during your lifetime, and at your death, the account is supposed to be closed. Now, again, theoretically, somebody could step into your shoes, and if they knew the username and password, they can continue to enjoy your account, but technically, there's no transfer of ownership to the next person. So, in many cases, you do actually have a digital file. And I remember purchasing music from a website, and I actually got a digital file of that album, and I could download it to my tablet. So I actually physically own that.
So you would own that?
I own that. And so in many cases, people have acquired maybe movies or music, and they have these digital files on their tablet or hard drive at home. And so they actually physically own those and can transfer them at death.
So that can go just as if it were
Yeah.
an actual album or a CD or...
Same as my vinyl records, I can leave all of my digital albums to you saved on my hard drive. Okay.
Thank you.
Yeah. So, what you need to do, first determine what you own and what you don't own, and then go to something called an online tool that each one of these websites will have. And I say websites, service providers. These companies, be it Facebook, Google, Microsoft, Apple, have online tools where if you go and find a section of the website or service provider that says, what happens when I pass away? What will happen to my account? There's actually a tool that says, here's what can happen. You could have the account closed, or you can have a representative take over. Facebook, for example. You post on Facebook.
On occasion.
I have never done so. I have a Facebook page. I have never posted. But there is something you can do to memorialize all of those posts that you have.
Kind of freeze them in place.
That's right. So you can name your daughter to take over, and she can post, she can memorialize your posts on Facebook so people can go back and see all of the great things that you
all
posted.
Of the amazing
all of the
things.
really educational and insightful thoughts that you had on Facebook.
I want to be sure and do that.
And you can do that with a lot of these social media accounts. Some of the accounts, however, just close when you're gone.
I just lock them up.
You're gone. And YouTube, I think iTunes, they are gone. If they know you're deceased, they will shut down your account. And there's not much you can do about that.
How do you let them know? Like, how would that happen?
They actually have instructions at the time of your passing. You can notify us that you passed away, and the account will close. Some of them close because they've been dormant for so long, like Outlook emails.
It just kind of fades out. So that would happen even if you're not deceased.
Yep. So I recommend, these are kind of like beneficiary arrangements in life insurance policies or annuities and IRAs. Just do it ahead of time. Make the arrangements. If you've got a Facebook and you're posting a lot, you want to make sure somebody memorializes it when you passed. Set that up through the Facebook organization. And that will control what happens, because the law here in Pennsylvania says if you've made arrangements through those online tools, that's what controls, okay? You can't override that.
So that's very much like a beneficiary designation.
It is.
And it might be nice because the person that you want to take over those digital assets maybe younger, maybe just more tech savvy than the person that you've named in those other roles in your life. Your
That's right.
agent under power of attorney or your executor. Might be a very different individual that you'd assign to that kind of
So
task.
you probably have your spouse in your power of attorney or in your will, but if you've named your daughter, who's younger than you, to take over these various social media sites, and that would be more logical. So in absence of using one of those tools, you can designate in a power of attorney or a will that someone will take control of your digital assets or digital accounts when you pass away. It could also include the electronic communications, such as emails. Now, in some cases, this law we have in Pennsylvania will actually override those terms of service agreements. In other cases, it won't. So if the terms of service agreements say all you have is a license, it's highly unlikely you're suddenly going to get ownership of the 1,000 albums you've saved on such and such music service. You're not going to get that. And even if you wanted to get at the content of something that was saved with one of these sites, it's not just that the agent can communicate with a site and say, I want to get in. In many cases, the Microsoft or Apple or iTunes say, okay, fine, you want to get in and see what's there, but we need a court order.
Court order.
Right. They're not going to just turn things over to you without that additional step of your agent or executor or trustee getting the order from the court. And then they'll turn over information to you.
There would have to be something really good on there to want to go through that process, I would think.
Yeah, and I've thought of what is it? What is it that you'd want to get into? And I think emails are probably, this comes from some civil case or criminal case. You want to get into the content of what was going on with the communications between people. So you want the email content. You don't have the username and password anymore, so now you've got to go to court and get this information.
So in most of the scenarios where we have mom and pop and this is, you know, they've lived a normal above board life, when they pass away, there's very likely nothing out there of interest that anybody would even want.
If you have an email communication about some topic, it comes and goes, and then you go on to the next communication. Why does anybody want it?
Right.
So most of those, email accounts are just going to be shut down after you pass away. Now, should you update your will or power of attorney to mention digital assets if you don't already have it mentioned? I think, keep in mind that most of these online tools are adequate for most of our clients. They don't need anything more because all they do is engage in social media and post things online. They don't actually have NTFs or Bitcoin. So if you fall into the category of the group of younger people who actually are going to have digital assets that have value, or maybe you're a vlogger and you have lots of content online and you want to pass that on to somebody else if you're incapacitated or you've passed away, you may want to think about updating a power of attorney or at least getting one. I mean, I'm thinking the generation that's into this quite a bit, they may not even have documents yet.
I think you're right. That first step is probably the bigger step.
Yeah, get the document in place and make sure the power of attorney mentions digital assets. Most of the good ones will. We've been mentioning digital assets for quite some time in our document. It just wasn't backed up by the state law. So you want to have some provision in your power of attorney that allows your agent to access and control digital assets. And secondly, you want to have something mentioned in your estate plan so at the time of your passing, the digital assets pass to a beneficiary along with your personal property. And you may want to make a specific designation that says all of your videos that you've collected over the years will pass on to someone. We get on YouTube, you can see the millions of views for some of these videos. They have significant value for some of these people who are making money online, reviewing movies or commenting on various, social topics and political topics. So they may want to pass ownership of these on to someone in particular, and now you can do so. You can pass on the videos, again, if you own them. And presumably somebody who's posting on YouTube, you own your videos. You're just using YouTube as a mechanism for sending them out to the world to view. So yes, the younger clients probably want to make sure that they have that information in their power of attorney, as well as in their estate planning document, whether it's a will or trust to pass ownership at death. Okay. One of the last things I'm going to mention that we do with our clients for many years, and this is even more important now with these digital online accounts, is that you need a letter of instruction.
Yeah.
You know what a letter of instruction is?
I do.
Okay. So here you would say to your loved one, let's say your daughter, here's all the accounts I have with various banks.
Yeah.
Classically, that was it, because kids don't know what parents own.
It's none of their business.
None of their business.
Until it is.
Here's what you own, and here's who you contact, okay? Here's what you contact for the various services. We have a lawyer, an accountant, financial advisor, if something happens to me. Well, now you've got to have these online passwords and usernames, and the very services you're using.
Yeah.
They want to shut them down when you pass away or memorialize them. They're going to want to know, what you want to have happen to these accounts in some cases.
Cleaned up, organized list of
Yeah.
what there is, who to contact,
Yeah.
or how to contact, and then what to do with it.
Where are the username and passwords located? It used to be with our clients, they have credit cards. So the clients would have credit cards, we'd find them, and the kids would go, okay, now we got to call the credit card companies and cancel it, right? Well, now you got to go online. Think of all the online accounts we have. This goes beyond just digital assets and what to do with them. This is, engaging with online content. And so we need a good letter of instruction for our loved ones going forward so that they can clean these things up. And what we're trying to do is we're trying to collect this information up front. We're trying to ask our clients at the time of the initial consultation, do you have digital assets? Do you have anything online that we should be mentioning to your loved one when they come in after you pass? And it's a tricky situation. Because we've mentioned this, that there could be online content that you really don't want disclosed, okay? And so dating websites, what's on there? And, there's a lot of different dating websites you can get into, and how much do you want to disclose? But, they're out there, and posts on some of these sites. You can post a lot of stuff. And so whether you want that disclosed or not, you're going to have to use some discretion, in terms of disclosing that to your loved ones at the time of your passing or incapacity. So we're reaching, what do we have here for comments, Patti?
We have a question from Jonathan.
Okay.
He's wondering about his parents not really being social media mavens. They don't do a lot of that. But do they need to pull this into their estate plan?
Okay. And I think I mentioned that if you're just on Facebook and you have an email account, no. You don't need to do anything unique here. You can go to the Facebook page and just arrange to have it memorialized by somebody when you pass away, and that's enough. And like I told you with the email, it'll be closed out, and you just have to contact Microsoft or Google, whatever it is you're using, Gmail, and just have them close out the account when you're passed away. It's an easy thing to do. You don't need anything special. So, anything else? Okay, nice comments. So thank you very much. So that gives you just the overview. And I will tell you, if you want a more technical insight or a deeper dive into the new law, we did an article and we posted it on our website. It's at Marshall Parker, palderlaw.com, at Marshall Parker's website, palderlaw.com, and Tammy Weber, one of our principals, did a nice article giving you all of the breakdown of the various sections of the new law, which deals not just with accessing the substance of what's online, but you can actually get a catalog if you have not specifically given somebody the authority to get the substance of the emails. And you can just get a catalog of the date it was sent to who it was sent without actually seeing the content. And so that's part of the state law now. It's a default provision. So if you didn't authorize somebody to go access your email account, the email provider still has to turn over a catalog of what these emails were about. Okay.
Jonathan has a follow-up question. What about the photos and things that have either been uploaded to iCloud? What happens to those when someone passes away?
Okay, it depends on what service provider you've used. If you're using social media, like I said, there's a way to memorialize those photographs online. If you have an actual, shared system, a shared file with these photographs, I presume you uploaded them from a phone or a camera, and so you actually have the actual photos saved somewhere in your possession, and you're just sharing them with someone else. So I think, if I got to read into John's question here, but I think it's some sort of file sharing service that you're using, and hopefully you actually have the actual files, the digital files somewhere in your possession in a computer somewhere, and those certainly can be passed on to someone. But if you're using some service, I don't care whether it's Facebook, Google, otherwise, where you're sharing content, you're always going to have those terms of service agreements. What you can and cannot do with the content after somebody dies is usually controlled by those. There's very little chance that you're going to be able to transfer the social media content to someone else when you pass away.
So maybe a tip, especially for seniors who are only savvy enough that the photos are the bulk of it, if you want to sit down and help them kind of gather them up on a separate hard drive, and then everything is in one place, and it'll be an easy transfer of that kind of thing,
Right.
in addition to having to get them from wherever you've
Right.
uploaded them.
Have a file on the home computer of your parents, have them all there, then have copies made to zip drives for each one of the kids to have.
That's a good
and
idea,
They
yeah.
can have everybody can have a copy. Okay, so there's a link to if you're following the various comments. There's another post there. Someone's a younger person. They don't have a lot of assets. It's worth creating documents strictly for digital assets. Like I said at the beginning, most of these don't have a lot of value. Now, the show I saw with the gentleman who sold a piece of artwork for about $70 million was an NTF. If you're in the NTF business and you're making that sorts of dollars and you're in your 30s, way to go. We missed our boat, Big J.
We did.
Yeah.
We are on the outside of that age
yeah.
group.
We're outside of that world, but if you're in that, you should probably have an estate planning document such as powers of attorney and a wills. But if you're not in that group and you just have the less valuable social media content and you have hard copies of your photographs, I wouldn't go out and spend a lot of money. Although I would say, in general, even if you're in the 30s, a power of attorney is a good document.
Yeah.
You could be in an auto accident, you could be incapacitated, so I'm not saying you shouldn't have one of those documents, but strictly for the purpose of managing digital assets. Most people don't have the sort of value in these assets that justify powers of attorney. So at this time, the world is changing in this area, so we suspect in the next 10 years we're going to be running into clients who say, I have the following. And it's going to be, wow, that's new.
It's going to be a learn and grow.
Yeah, and we're going to have to adapt.
That law's going to continue to
Yeah.
evolve, I think.
And we have this client information questionnaire that you always update, and now it has a question about digital assets, Bitcoin. We have to put it on there because it's now part of our world. And so, well, with that, we've reached the end of our time here, so I want to thank you all for joining this Facebook Live presentation on estate planning and digital assets, and we'll be doing more of these in the future.
Great.
All right,
Have a good
PJ.
day, everybody.
See ya.
If you want to save or delete.